All right, couple in the red jacket and gray, y'all need to separate that, this is not, Valentine's Day or anything. Oh, that's okay. The love you showing her in court, you need to be showing it on the outside. So when I see you walking outside, you all better be holding hands or something else. Celeste, is it Celeste or Celeste?
Celeste.
Celeste Juarez. I have a friend named Celeste. She said that's not how you pronounce that. But we're gonna find out. How do you pronounce your first name? All right, you're pronouncing it incorrectly. My friend, okay, Celeste said, Celeste Celeste Ramirez, she told me it's Celeste.
Yeah.
Am I right?
It's fine if you can say.
Thank you. See, I'm correct. Thank you, Mom, for letting me know I was correct. Guys, I'm trying to learn my Spanish. You can't be throwing me off. All right, Jose Martin Garcia Corona. Yeah.
He's been transferred to ICE custody. And I'm
Sorry, he's been transferred where?
to ICE custody.
Okay,
So I'm not sure what the timeline is for him.
all right. State? On Jose Martin Garcia Corona, this is a possession less than a gram. He's been transferred to ICE. So what are we doing with this case? Is this case just gonna sit around forever? Because I don't think ICE is gonna hold somebody for a possession less than a gram case. Yes, so what are you planning on doing? Are you planning on holding this case forever, even though it's a state jail felony and he's going to be deported? Because ICE is not going to release him to come back here for possession less than a gram case. So what is going to happen?
On this one, let me talk to our supervisor, see what we want to do with cases like this, Joe.
Okay, how much time are you requesting?
Just for like a week or 2 weeks.
All right, Ms. Ferguson, on this one, can you set it the end of March?
Yes, ma'am, I can do March 31st.
All right, so we'll come back on March 31st.
Thank you, Judge. May I be excused?
You're welcome, thank you. Yes, you may be excused.
Thank you.
Who's here on Crystal Molina?
Good morning, Judge.
Good morning. So where we're on this?
We
case?
have money today. We have
Oh, wow.
$5,000 in a
How
cashier's
much?
check, 5,000.
Okay, awesome.
Mhm.
Then let's proceed.
Okay.
Ms. Abrams, on this sentencing, they have $5,000 for the complaint, and if you can instruct them where they need to deposit that. All right, we're here for sentencing, correct?
Correct.
All right, the court is calling 2024 CR 4065 State versus Crystal Molina. Can I have parties announced for the record for the state?
Nicole Thornborough for the state.
Monica Anna Guerrero for defendant.
And are you Miss Molina?
Yes.
All right, you entered a plea to count 2 on December 19th. According to the plea bargaining agreement, punishment was to be assessed at 2 years in the state jail facility. There's a $2,000 fine. There's no application for deferred adjudication. There's to be restitution of $10,000 to DZ Industries. And you were to agree not to be employed in a capacity where you are in control or handle any type of funds that are not your own. Are parties ready to proceed with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Not right now, Your Honor.
All right, so my understanding, since you have the $5,000 cashier's check, and is that made out to DC Industries?
It's made out to Bayer County CSCD.
All right, so Ms. Abrams, if you can make sure that that goes directly to restitution. All right, then, so the remaining restitution amount would be $5,000, is that correct?
Yes, sure.
Yes.
And Ms. Abrams, on this case, if you could make sure they set up a payment schedule for her, and if she missed any payments towards restitution, let the court know so we can have a compliance hearing. So do you have any children?
I do. I have one son. He's 23 years old and a grandson.
All right, how old is your grandson?
A year and a half.
And what do you do for employment?
Well, I was doing accounting.
Okay.
sales, customer service.
So, I mean, are you currently employed?
I am not, I'm looking.
All right, so in this court, I require that everyone have employment. If they don't have employment, there needs to be a reason. For example, if they're on SSI, then they need to provide proof of that. Do you understand?
Yes, ma'am.
All right, the court is going to sentence you to the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. If you're able to pay off everything early, then the court will reconsider.
I just want to clarify that it's 4 years that we agreed on.
No, that's outside your agreement.
Okay,
It's just what is recommended by the state. If you complete everything early, then you can perhaps be terminated early. Do you understand?
Yes, ma'am.
But the key about this probation, you need to pay that $5,000. Do you understand?
Yes, ma'am.
All right. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors or in any occupation where you are in control of any type of funds. So you can't be a cashier, you can't do any of that. Do you understand?
Yes.
to clarify for my client, employment with minors or elderly, is that what it was?
Home healthcare
Healthcare.
provider. So
Okay.
she can't be in any position where you're working with vulnerable people.
Okay.
So for example, the home healthcare field, you're not to be help someone at their home. You're not to take care of the elderly. You're not to take care of minors. Do you understand?
Yes, ma'am.
So if you want to work at a fast food restaurant, you can work at a fast food restaurant. If you want to, well, you're really limited since you're not able to handle money. You're not able to be a cashier.
Right.
So if you want to work at a restaurant, you can work at a restaurant. They can give you your tips. That's fine. But anything where you are involved with exchanging money, you're not allowed to do. All right. If you want to be a hostess at a restaurant, you can be a hostess. All right.
Yes.
Or if you want to be a welder. So no involvement, no occupation involving the transfer of funds. And I'll give you 45 days to
45
find employment.
Yes, ma'am.
There's to be 200 hours of community service restitution. You okay? 100 hours will be waived if you decide to obtain a higher level education, or if you decide to obtain a certificate for welding or anything of that nature. You understand? And if there's something else that you would like to do to improve yourself, then just let probation know, and I'll consider deducting the community service hours for that. You understand?
Yes, ma'am.
There's going to be field visits 1 time per month for 6 months. There's to be restitution of $5,000 to DZ Industries. And that restitution amount, Ms. Abrams, is just what she will owe remaining on the $10,000. Yes.
Thank you, guys.
And I'll notate in the docket sheet that you paid $5,000. There's a $2,000 fine that will be probated. And can you tell the court, why did you take these fines?
I don't want to give you an excuse. It was just a bad choice on my part. I mean, I can give you the excuse.
No,
but
no, give me the,
Moving forward, well, I was a single parent. I know it's not an excuse because I could have got a second job.
yes.
But it was just a bad decision.
All
And moving forward, I would like to do what is necessary by you and the courts and probation and move forward.
All right, and the reason why I asked that question, I asked that question so that I'll know if there are any other courses that are needed from you, okay?
Mhm.
So, Ms. Abrams, and I'll deduct another 100 hours from the community service, but I am going to require you to complete the MRT course. All right, is there anything else, Ms. Abrams? Is there anything you need from the court to be successful?
No.
All right, we can go off the record. Here's the thing, in this court, to be successful, communication is key. If you're having an issue, let your probation officer know about it. If you feel as though they're not addressing it, then you can always come back to the court and we'll figure out what's going on.
Okay.
All right, good luck to you.
Thank you
And
for your
thank you. You
time.
always dress appropriately for court. I appreciate that.
Thank you.
Have a good one. Yes.
Just to confirm, what count we're going on that one?
Count two. You're welcome.
Thank
Thank you. Thank you. Lindsey Hernandez.
President, Your Honor, on Ms. Hernandez's
Yes.
behalf. Yes, Judge, received notice that she's in inpatient treatment. I got a notice from the case manager there. She's currently in detox, so I know that there was some concerns that she needed to start that phase in order to get more meaningful treatment, Judge. I spoke with the state's attorneys on it. They're not opposed to continuing her matter, Your Honor. I believe her misdemeanor is set in March, and we would be requesting that date. I think it's March 27th.
Is it March 27th?
I think so, Judge. That way she can come on both and check in on both her cases then.
All right, Norma, on Lindsey Hernandez, can you recall this for March 27th? My understanding is his client is in detox.
That's correct, Judge. And I'll go ahead and notify him to relay that to her so that when she finishes checking with.
All right, thank you. All right, court is calling 2025 CR 0000286, State versus Joshua Dwayne Pollard. Could I have parties announced for the record for the state? Defense,
Kelly Piddle.
and are you Mr. Pollard?
Yes, ma'am.
You're charged with unauthorized use of a vehicle as a repeater. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
So part of your plea bargain agreement, you to plead true to enhancements for purposes, as part of your plea bargain agreement, you're to enter a plea of true to any of one or more felonies for purposes of enhancement. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. There are no applications. The state is taking in consideration 2024 PF 20093. And there's to be restitution of $1,700 to Liam O'Neill. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes.
State is at the plea?
It is, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement paragraph, how do you plead? True or not true?
True.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No.
All right. Then the court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served, take in consideration 2024 PF 20093. There's a $2,000 fine. There's to be restitution of $1,700 to Liam O'Neill. And there's to be no contact with Christopher Adams. All right, we can go off the record. How old are you?
41 minutes.
All right, you're gonna have to start making changes. Otherwise, you're gonna look up, majority of your life is gonna be in somebody's jail or prison. You understand?
I understand.
All right, good luck to you, okay?
you.
You're
Thank
welcome.
you, Judge.
Celeste Alexandra Juarez. Hello.
Morning, Judge.
Good morning. All right, so I'm in receipt of a motion for discovery and inspection. Did you review this with defense?
Yes, I have.
All right, any objections to any of the requests?
Just a couple, Judge, under section 1, I'm sorry. This is going.
That's okay.
Under the first request, state would ask that exclude any work product. Whenever I meet with a victim, I do a summary of anything that may be related to provide that to them. Product, and I would ask not.
Our intent is not to ask for a work product. My
So with
concern though,
regards-
my concern in general, and not with Ms. Brown, because she is definitely thorough. And then, as you'll see, I think she's gonna put in another disclosure. I think if there's a statement that that's not work product. And so her notes may be work product, but the statement is not. And so I just want to make sure that if there is a statement that we're aware of it, and then definitely if there's nuanced differences or differences between that statement and what we received, that we receive that.
Well, with regards to your notes, are there a synopsis of the meeting? Or are you taking word for word?
Oh, no, they're synopsis. They're literally just like quick jot down. Somebody will say something and I'll jot down 2 words. And then I'll go type something and I'll be thorough using thoughts and put full sentences together.
All right, the court then is excluding the work product. Counsel, if you feel if there's something, I can do an in-camera inspection.
Thank you, Judge.
All right, we're gonna go on the record in 2023 CR 2023 CR 8101 State versus Celeste Suarez. Can I have parties announced for the record for the state
State.
defense?
Jason Todd for defense.
And are you Ms. Suarez? All right, so off the record, with regards to number 5, motion for discovery and inspection filed by the defense. With regards to number 1, the court is granting that based upon the agreement of parties. It will exclude state's work product, but if necessary, the court will perform an in-camera inspection. All right, with regards to number 2.
Judge, there is none to my knowledge, but if I discover that there is, I will disclose it.
All right, that'll be granted. With regards to number 3.
State has already provided a witness list to defense. The only thing is we don't have personal addresses for the victims due to safety issues. We have for the officers and the school professionals, we have school addresses, the work addresses, or work information. To the best of my ability, and if I find more information, I'll provide it.
All right, so the court, based upon the state's representation, do you have any objection to not including the addresses of the complainant?
Well, Judge, I understand not filing it in a public record. I also, though, I don't understand the safety issue of disclosing it to defense.
All right, so what do you want to do with the address? You want to go out to the address of the complainant? Is that in some way related to the alleged offense?
If there were reports we wanted to know if there's been calls to the house, if we wanted to do research on the complainant, we would not. That being said, we have the address of the complainant, so that's not the issue. I'm just.
All right, so you already have.
I have that address, but safety concerns for if there's more than the complainant, we need the ability to research these witnesses, and we need the ability to know what's going on regarding their
Well,
testimony.
my understanding is the only thing the state is not wanting to turn over is the addresses. Is that correct?
So it's the addresses of the complainants, and I'd have to look over, I'm sorry, I don't have my witness list. It's the address of the complainant and complainant's mother, guardian.
Well, he says he already has the address of the complainant and the complainant's mother, so that will be excluded. You already have it.
And
Yes,
the
Judge.
personal addresses of the professional witnesses, but they are identified by the order placed to the best of state's ability. And
All
if additional information comes, I will turn it over. I'm giving you your word ready.
right, with regards to professional witnesses, I'm assuming the professional address for their business. You don't need their home address, do you?
We do not, just the ability to contact them and reach out to them if that need should arise.
All right, I'm going to notate that defense has in its possession the address of the complainant's address, so that's not needed. So what I'm going to order is that there is to be state, you're to turn over all the names and business addresses of individual witnesses. And if for some reason there is an address that you feel that you need, that is a person's personal address, just come back and we'll have a hearing.
Thank you,
But
Judge.
that'll need to be done, not at the last minute.
Understood, Judge.
Okay. Number 4.
To my knowledge, Your Honor, there is no informant in this case. If one becomes known to the state, we will disclose it.
All right, thank you. And let me ask you all this, is CPS involved in this or no?
Yes, Judge.
All right, so sometimes the confidential informant could be the person who reported it.
So CPS comes in after the initial report to law enforcement. I think, was it law enforcement or without CPS, I think?
I would have to look at the timeline. CPS is, we know who told CPS. I will say that. I don't think that's an issue in this case, Your Honor.
All right. Because if it is, then my ruling on this, granting it, I'm gonna rescind that because that's supposed to be confidential.
I understand, Your
All
Honor.
right.
I don't think that's an issue, though.
All right. And number 5,
That's to number 5, Your Honor. The only issue state has is.
everyone, please whisper. And everyone, we're on the record, so no talking behind the court reporter while we're on the record. All right, number 5.
The only issue is the rank and badge number of the police officers. Some of them have changed agencies, some of them have retired. I don't have all of their badge numbers or rank. As to what information is current and that I can provide, I will provide it, but I don't have all their historical information for what their rank was. And I also don't know if he wants rank at the time of the offense, badge number at the time of the offense, future badge numbers. It's a little vague for me.
I guess my response would be to that if she gets updated information and she's talking to her witnesses, if we get to the place where we're prepping for trial, we need the ability to know where her witnesses are. If she's, I have no doubt she's given us what she has, but if she finds out something new, I think we do
Okay.
need to know that.
So as far as where her witnesses are, that would be taken care of with regards to defenses number 3. So
I-
do you really need to know the rank and badge numbers?
Yet the rank is helpful, but the badge number is important because if this law enforcement officer has moved to a different agency or within the agency, if we want to look them up and look up what they have, perhaps discipline or get information from the agency, I have found the easiest way is a badge number.
All right, so you don't need their rank.
I guess I don't need it.
All right,
It does.
so then if you have the rank, then give them the rank. But if you don't have the rank, then she doesn't have the rank. And it is vague based upon what she's stating. Do you want their rank at the time they were involved in this, or do you want their rank now? So if you have their rank, give it to them. If you don't have the rank, and if there's an issue, then just come back to the court. If you have their badge number, give it to them. If you don't have their badge number, then come back to court.
Thank you, Judge.
And I'll write that the defense is to approach well before trial if there's an issue with the rank and badge numbers.
And if you, Judge, I have my phone out, but I'm just taking a note.
Sure, oh, no problem.
Thank you, Judge. Thank you. Thank you, Judge,
You're
for
welcome.
that indulgence.
All right, and then number 6.
There is no issue with that request, Your Honor.
All right, is there anything else?
As to the motion and the specific order attached, Your Honor, I would just ask that if the defendant needs to physically pick up any tangible items that are not able to be transferred via e-discovery, that they come pick them up here. They're in the building every day, and I don't have a work vehicle to take them to the office.
And we're fine with that, Your Honor.
All right, so I'll put on here. All right, so State, have you gone through each order that they're saying they want 48 hours, within 48 hours of the time it learns or obtains discoverable matter?
Yeah, Judge, if it's within 20 days prior to trial, yes, we're gearing up for trial, that's fine, Judge. I'm pretty.
All right, so you've read through the order and you have no objection to the court signing the order as is, but the court will add the line that if there's anything that needs to be physically transported, the defense needs to come and pick it up from you?
That and just with the provisions regarding the product, if that's somehow incorporated into the order, that will probably not be turned over without being.
All right, so if you all will write the additions to the order, the court will sign it. All of the other discovery has been tendered.
I'm sorry, what was that?
All of the other discovery has been tendered because the last time we were here, it was the complainant school records, CPS, any additional records, the IDR, dispatch received, calls for service, statement made by the school nurse.
So regards to those items, Your Honor, We had turned over CPS, defense police, there's items missing. We're gonna send a more specific to Davina to specify those items and see if they're turned over. There was some body cam that defense believed existed. We asked about it. I just found out this morning that that body cam does not exist any longer. It did once, and no longer does. We're getting an affidavit of no record, and I've provided a written disclosure defense regarding this revocation. As far as the IDR, CAD, all of that, there's one thing that relates to those items, and we have turned that over to defense. The nurse's statement was turned over. We clarified with the nurse or with the detective that the only statement made by the nurse was the nurse's reports. And so we've gone through each of those items. The only outstanding issue is the affidavit of no records for those body cam videos and the requesting the CPS to see if there is additional material that can be displayed, can be turned over. We did request all CPS records prior, but sometimes if you don't specify videos, documents, et cetera, sometimes they don't mind doing it.
All right. Defense?
That is an accurate depiction of where we're at, Your Honor.
All right, so this is what's gonna happen, and this will be your last setting for discovery, and if there are items that are missing, or you see that when we have this next hearing, that there are gonna be items that are missing, you need to subpoena witnesses to have them here. They can appear by Zoom if need be, but this will be your final discovery. And also on this date, state if you have not, you'll need to tender an offer to the defense.
We are in negotiations with the federal government. I don't think we have a firm one at this point, but we've been talking.
All right, so Ms. Ferguson, recall this for March 27th.
I'm sorry, Judge.
Yes.
I'm unavailable on that date.
Okay. Oh, I'm so sorry to hear that. What is a good date for you? I was just trying to give you a longer setting.
I'll be back the following week, the first week of April, Your Honor.
And if you all don't have the remaining of the discovery, then witnesses will need to be subpoenaed to be here on that date,
I'm so sorry, Judge. What was that date?
April 1st. You're welcome. And defense, if your client wishes to appear by Zoom, your client can appear by Zoom.
Thank you, Judge. We appreciate that.
And what page is she on, Ms. Ferguson? All right, if you can have a seat. Thank you so much for dressing appropriately for court as always. Just have a seat and the coordinator will bring you a reset form. And once you sign the reset form, you're excused.
Thank you. Have a great day.
All right, thank you. You too.
I'm gonna finish the order and get that back to you.
All right, thank you. Brennan Short.
Present, ready, Judge. Or I should say I'm present, Mr. Schwartz.
All right, where's Mr. Short?
He's still in Fed custody, Judge. and I'm gonna have to follow the sword, I guess, again. But I believe Gutierrez has been in contact with Norma. And she admits that she messed up again. And
Okay,
the person was not requested. However, I think she has all the ducks in a row now. She needs a setting at least 30 days out. And that's because PCSOs requires the 30 days, but everything is set up. All we would require at least 30 days set out when it's at this court's discretion.
all right, April 1st. All right, Norma, if you put this on the docket for April 1st.
Thank you, Your Honor.
Thank you.
You're welcome.
Sorry about that.
Oh, no problem. Dustin Murphy. Who's the attorney for Dustin Murphy? All right, counsel, you're on this side.
Thank you, Your Honor.
Why were you late for court?
I haven't been downtown or to court.
I'm sorry, what?
I haven't been here in a while, so.
All right, so don't be late again. You
Yes,
now
ma'am.
know where it is. You understand? All right, where are we on this case?
Judge, I have asked the prosecutors to take a look at the body worn camera. I think it was the version I have, I think is too short.
Okay.
Also, I asked them to look for Coban, even though the Senate Bill 111 indicates there is no Coban. It's kind of strange. It's a lieutenant doing patrol, which is kind of strange.
Mhm.
Also, there are some pre-filed cases that have yet to have labs come back on them.
All right, these pre-filed cases, what are they?
There are 2 drug cases, Judge,
And what is the alleged amount?
4 to 200.
All right. All right, Ms. Ferguson, recall this for discovery on March 31st. And state,
Yes.
do you anticipate having the labs back on the other cases? When,
Surprised before, surprised again.
all right, so let them know that I want to be surprised. If you can call them and tell them the labs are needed for that. All right, thank you. Is there anything else?
No, Your Honor. Thank you.
Right. You can have a
Appreciate
seat once you sign the reset form. You will be excused. And I can't believe you're in here with a Texas A&M top and you're in front of an LSU's Tiger.
I'm sorry
I don't
about
know.
that.
I don't know. I don't know.
I have a piece of paper to you.
That's okay. We're cousins. All right. All right. Court is calling 2022 CR 5005 State versus Pedro Rodriguez.
We're ready, Judge.
All right, if y'all could approach. Never have parties announced for the record, for the state,
Rick Bader for the state of Texas.
for the defense.
David A. Garcia, attorney for Pedro Rodriguez.
Are you Mr. Rodriguez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Pedro Rodriguez who was placed on deferred adjudication in 2022 CR 5005 for the offense of assault, bodily injury, family, household on January 9, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
The state will be proceeding on its motion for adjudication of guilt and revocation of supervision. Violation condition number 15, on or about the 29th day of July, 2024, in Bear County, Texas. The defendant, Pedro Rodriguez, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, anger management program, violation of condition number 15.
How do you plead to that? True or not true?
State will waive all other violations, Your Honor.
Any objection?
No objection.
You understand by pleading true to violation of condition 15, the court can find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to violation of condition number 15? Is there proposed, the court will find violation of condition 15 true? Is that proposed agreement?
Yes, Your Honor, is to revoke the defendant's probation on the case and sentence him to 115 days in Bear County Jail. Give him credit for time served, final months currently, and it will be affirmed to Brennan.
That is the agreement, Your Honor.
All right, has he done anything on probation?
He did quite a bit, I believe. He did pay some. He reported. He took a lot of urinalysis tests. Most of them were negative.
So why didn't you successfully complete this probation? You can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Pedro Rodriguez.
All right, why didn't you successfully complete probation? You're whispering.
Ran into problems.
Oh, what problems were those?
Judge, he's currently been indicted on another charge out of this court. We wanted to kill this and move forward on that case.
All right, the court is finding you guilty. The court will grant the motion. There's an affirmative finding of family violence. The court will sentence you to 365 days in the Bear County Jail, give you credit for any time served. There's to be a $4,000 fine. All right, the other case he has pending out of this court, has that been indicted?
It was indicted just in January, in December, late December.
All right, could somebody give me that file?
And Judge, regarding this, I believe state was recommending judgment sat.
No, I'm not doing a judgment satisfied. And I'm going to give you a date for your new case.
And Judge, regarding the new case, we would just ask that the state look into the discovery of CPS records.
Okay. We are going to do that, and I'm going to give him a date. That way you won't have to come back. And let me see what page he is on. All right, so with regards to this case, and we're off the record, this is for the 2024 CR 012355. We were here in January for CPS records. What's the stance on the CPS records? Do you have them in your custody? Or I should say in your possession? All right, other than the CPS records, counsel, is there anything else?
Other than that, Judge, I think the CPS is the records will allow us to look and see about any other allegations that were made against any other innocent people that were charged.
All right, we're gonna call this back on March 31st.
Judge, I'm not gonna be here that day.
When will you be here?
Anytime in April, Judge.
All right, we'll recall this for April 1st for discovery, Ms. Ferguson. State you need to be prepared to tender an offer. All right, is there anything else?
No, Your Honor.
All right, thank you.
That's in March.
April 1st.
All right, Mr. Galan, you need to show your video. So counsel, where are we on this case?
The CCA's website this morning, they still have not come down with a decision on the case Aaron Wells v. State in regards to the geofence. And so we're still waiting for a decision, Judge.
All right, Ms. Ferguson. Recall Galan for April 1st. All right, thank you.
Thank you, Judge.
No, he can be by Zoom. We're waiting the results or the decision from the appellate court. And Mr. Bradley, you need to make sure your phone is working appropriately next time.
Page 6.